All right, yes, welcome to the No State Project. I'm your host, Mark Stevens, author of Government Indicted. Website, of course, is markstevens.net. And we are live here. Hopefully, everything's going through and the audio is good. It is August 30th, 2017. And this is episode 32 of the live edition of the No State Project. Episode 32. Glad to be with you here from the fortified compound in Mesa, Arizona, where it is beautiful, about 104 degrees. So it is cooling down. It is cooling down. Hopefully everything looks pretty good here. I'm sorry, for whatever reason, my webcam is not doing HD, but hey, it's still better than doing it on Ustream because there shouldn't be any commercials on the content. But it's a radio show. It doesn't really need to be in HD. But I'm glad to be with you here. I would give out the caller number, the typical one, but as if I didn't have enough tech issues on this broadcast to begin with, my caller line is down. So the Free Conference Pro is down. So I don't usually do this, but if you want to join me here on the big show, you can do so with my regular number. Please don't call this during, off air, when we're not on the air. This is unless you have an appointment. But first try to Skype me at Frank Rizzo 3. That's Frank Rizzo with the number 3. Oh, looks like we're doing okay there. Yeah, we're coming through loud and clear. So good. I'm glad to hear that. And yeah, loud and clear in New Zealand. So g'day, mate. Well, I don't know if that's really New Zealand, but anyway, try me first on Skype. Skype is Frank Rizzo 3. It's Frank Rizzo with the number 3. So try to instant message me first if you want to join the big show. Send me an instant message and then I can, instead of just calling, and this way I don't want to have a whole bunch. Let me put this on mute just in case people start calling into the broadcast. You can also, if you don't have Skype, you can join me. Again, this is just for the show. 602-635-1974 or 632 602-635-1974. 602-635-1974. I guess I could put that into the chat there. So it's 602-635-1974. So there, if somebody wants, yeah, I just put it up into the what do you call it? Yeah, into the YouTube stream, so you can chat. Yes, you can not only chat with me on the live chat on YouTube, but also on Frank Rizzo 3 on Skype. So it looks like we're a go. And I don't think anybody, we're not going to complain that it's not HD. I will, when the things I describe, I will probably post, do some editing. It would definitely get posted what I mentioned before. Oh, well, I kind of forgot to do that. So anyway, we've got that. Anyway, so what we've got here, this is great. And I know there's a lot of things going on. And well, why are you, somebody posted recently, someone I've known for a long time. They haven't posted in a long time, but it's just a minuscule little thing that we're doing here. Why do you talk so much about traffic tickets? What is the point? How does that have anything to do with the big picture that we want to get to a free society? We want to get to a society where the rule of do no harm, basic morality applies to everybody, that we don't have a ruling class, that we're not being ruled over by a small oligarchy or whatever we want to call them. What the hell does traffic tickets have to do with that? Well, because we're giving people the tools here to defend themselves and to critically analyze the garbage, the claims that are being thrown at us, that are used by the people who rule us to keep us conditioned so that we don't ask certain questions and that we'll feel that this isn't something that we can necessarily challenge. What's the point? Okay, so we show that you can. The tools using the Socratic method of critical analysis, using basically the basics of the scientific method to challenge these assertions and to not only challenge them, but to get them thrown out. Because what we are showing here is not that we're just getting a traffic ticket thrown out. We're showing that we can go up against these people and defeat their claims. And it's teaching people and empowering people to not just sit back and take it, but to actually challenge them. So it may just be one. It may just be one this week or one next week, but there's a growing number. Not everyone is getting the ticket, but people are going, like Tony from last week, people are going to court or to city councils, and they're challenging them. And this is becoming more and more, hopefully, more prevalent. It's not just Tony over there. Although we appreciate, Tony's going and doing that. So we're challenging the entire system. We are showing that and how one individual can go up against the system and not only get it thrown out, but the background of it's why we're getting these things thrown out that are so important. Not just because the traffic ticket was thrown out. Yeah, traffic tickets are inconsequential. But it's the fact that we're empowering people, and more of us are challenging the orthodoxy. That's considered heretical. You'll actually hear people say, are you actually challenging the application of the laws to you? Are you actually challenging whether the laws apply to you or not? Yeah, we are. If someone's making a claim that these rules, called laws, because they're just rules, if someone is making a claim that they apply to us, then, yeah, we're challenging the claim. Well, you can't challenge the laws. The laws are just written instruments, written by men and women who force us to pay them. That's it. And you really get to see that in action when you have a low-risk kind of challenge this way with a traffic ticket. So this is from Chris. And Chris is in Tennessee. So this is the Jacksonville, Tennessee Justice Court. And Philip Grimes is the Justice of the Peace for Precinct 3 of Cherokee County. It's like, Cherokee County, the Trail of Tears, you force people off their land and then use the names. That's sick. Just like on Long Island, you got Syosset and Hauppauge and whatnot. So you push all these people off their land, you steal from them, you kill them, and then you memorialize the murder and theft and rape of an indigenous people by still using the same names. Yeah, this used to be just that constant reminder there. So yeah, Cherokee, yeah. Well, the irony's not lost. I'm not, yeah. Anyway, so this comes from, again, a traffic ticket from over a year ago. Yeah, they held on for a long time with this one. And the charge, and I'll have this in the video. If I am not able to edit that, then I'll do a separate video with this. But I will have in the show notes on markstevens.net, I will have, for this episode, I will have the actual document. And I will link it in the YouTube comments. So yeah, for the notes for this particular broadcast. So you want me to do a blurb about admiralty law? Yeah, guys, I can talk about admiralty law. Let me discuss this first. He committed the horrible crime of driving an automobile or traveling in an automobile. Really the same thing. Without having it registered. Without having it registered. Now, I don't have too many details. Maybe I can do a separate video with Chris and he can call in about it. But from what I do know, he did file it, defend against this crap, the way we typically do it here on the No Stay Project. And that is to file a motion to dismiss, which I do have a template available at markstevens.net. And again, what we talk about here on the show, a whole model of how to effectively defend yourself in court or out of court when you're defending against these bogus claims against you. A whole model is in Government Indicted, which, of course, is available at markstevens.net and as an ebook. And yes, it does have an index. So, filed a motion to dismiss and a Brady request. Well, what the hell is a Brady request? Someone just asked me this recently on YouTube, and again, I don't usually have the time to respond to all YouTube comments, although I'm glad that most of the comments I get on YouTube are pretty good. Not too many cancer-inducing ones, which is always a refreshing change. So The motion to dismiss and Brady request. The Brady request has to do with any exculpatory information or evidence and that can be used that the prosecutor has in his possession or is obligated to have through a or that a reasonable that he should have based on a reasonable investigation before pursuing prosecution, and anything that comes up after that. So if something comes to the prosecutor's attention that shows that you're innocent, they have to disclose that. And Brady material is also about impeachment information. So if there's information that impugns the integrity or the credibility or competency of the witnesses being used against you, that is Brady material. It is discoverable. They have to disclose that to you. So you would ask, well, Mark, if the prosecutor, who is a Juris Doctorate and a very educated man or woman, if they have exculpatory evidence, why wouldn't they just give that to you? Why would they have to have some, a court case that says they have to do that? Why would anybody want to prosecute an innocent person? Oh, because lawyers are not honest. And prosecutors, it goes doubly so for prosecutors. They're interested in convictions. They don't give a damn about you. They don't give a damn about anybody but themselves, and they care about where they are in a political pecking order. They live by convictions. And it's the rare prosecutor that will say that is not the case. That they want to see justice done. They only want to punish the truly guilty. Yeah, that's not the rule. That is the exception. Oh, how do we know that? Because things got so bad that a Judge Kaczynski in the Ninth Circuit Court of Appeals had to go in a dissenting opinion a number of years ago, stating that Brady violations are at epidemic levels. Epidemic! And he gave a laundry list of cases from state and federal courts to back that up. It is pretty. So they do it because there's money and prestige, and it's called position. Conviction at any cost, which is why these former prosecutors, this is why you can look at judges. Well, why would judges, how can you say judges are so corrupt? Where the hell do you think they're getting the judges from? Some come from private practice, but the overwhelming majority of them are former prosecutors. So they're used to withholding evidence, which also gives them some insight as to why there's, an epidemic. Because the judges are allowing it to happen, and the judges allow it to happen because they used to be prosecutors, and the judges allowed them to do it so that they could advance on their political career. That's the way it works. So this is what we file that. Almost a year later, he has a jury trial set for September 11, 2017. A jury trial. This is he's looking at some time. This is a very, very serious charge. Now, you could just say, well, Mark, it's just the traffic. When they are impaneling a jury, they're looking to possibly put you in jail on this misdemeanor. That's pretty serious. Also, considering the fact you can go to jail for asking a question, yeah. So, I'm going to say to Toast the Strudel there. I love the username. Tennessee is a pain when dealing with their courts. Tennessee is no different. Don't let anybody kid you. Tennessee is no more corrupt, no less corrupt than every other court in whether it's in Montana, whether it's in Vancouver, whether it's in New York. It doesn't matter. They're all bad. All of them. They're all criminal organizations. They're all bad. All of them are bad. Oh, they're all damn criminals, I'll tell you what. So we filed this, and so almost a year later, after being challenged by Chris through the motion to dismiss and the Brady request, and I want to point out too, Brady is extremely important. I spoke to, he's been on the show, I believe he's been on the show, but Eric in California. I spoke to him today, and so it reminded me, he actually paid lawyers, and he's being prosecuted for a misdemeanor charge. And despite all the money that these two lawyers, two Juris Doctorates, these are very, very smart people, neither one of them would file a Brady request. That they just say, well, we're going to take the prosecutor's word that this is what they got, and that's what they're going to use. Holy crap. Do they understand what the word adversary means? These lawyers, even if they're nice guys, they're your adversary. They're trying to hurt you. They want you to be punished. They are not your friends. The idea that a defense lawyer who's supposed to be zealously defending his client, I know he's an officer of the court system comes first. But somewhere down the line, he has an ethical obligation to defend his client and the best interest of his client. Yes, to administer justice while seeing to the best interest of his client. I agree, administration of justice comes first. So, why in the world would these two very expensive lawyers not want to do even a copy and paste basic discovery request with Brady material? Oh, okay, I'm not going to mention, I don't know. The ticket itself was in, oh, yeah, Chris just told me, maybe she, yeah, I made a huge mistake here. Hey, there's got to be problems on the No State Project, but it comes with the territory. It's Jacksonville, Texas. It's Cherokee County, Texas. I guess the Cherokee kind of threw me, and it fit my narrative about the Trail of Tears. Yes, Chris is actually in Texas. Philip Grimes is the Just of the Peace for Precinct 3 in Cherokee County, Texas. So, yeah. Thanks. I appreciate that, Chris. And that goes for anything I may say here. If I say something that's in error, please, I have no problem conforming my belief and my statements to the actual data and to the facts. That's what the show is really about. So, but after all this time, instead of the prosecutor actually just providing the evidence that we were requesting, instead, it says here, the county attorney has made a motion to dismiss the above case, and Judge Grimes has signed an order that it be dismissed. A copy of this is enclosed for your records. We will not, and that's bold and underlined, we will not be having a jury trial on this September 11th, as this case has been dismissed. If you have any further questions, you can contact the county attorney. So what are we actually challenging here? I want to be mindful that we've got a great new platform here, so we got a lot, more people are able to watch the stream and participate in the show. So I don't want to leave anybody out that's new. That the big reason why we're getting these thrown out, I believe, is that there's no evidence whatsoever to show that their rules apply to us. Yeah, they say they do, but especially, when you're in court and it's supposed to be proven beyond a reasonable doubt, every element, they have to prove jurisdiction. Yes, there's some back and forth with the jurisdiction, but most, at least the judges, when you actually go into court, they agree jurisdiction's a trial issue, which means it has to be proven beyond a reasonable doubt. And you don't prove something beyond a reasonable doubt by starting with an assumption. I mean, that's basic common sense. If I'm wrong, somebody pointed out, how could you possibly prove something beyond a reasonable doubt if you start with an assumption, when the entire foundation that sets the relevance for everything else you're trying to prove, if that is an assumption, that alone is your reasonable doubt. At least if, you're capable of critical analysis and thought, and you don't just take this crap that's handed to you, if you actually question things like an adult. Although I shouldn't just say that. Children question things too. They're some of the best ones. But why? So they're claiming that their rules apply. The evidence that they rely on, there's never, you got nothing. There's not. What they'll do is they'll lie. And I have another video coming out about this. It's going to be a very short video just going over some of the things we talk about here on the show and getting these tickets thrown out. Kind of an introduction thing to new viewers, new listeners. So their basis is that they're saying, here, for example, like Texas, they're trying to say that a written instrument, something at the time done only by men, applies to everyone in a geographic area the size of Texas, which was actually a bit larger at the time. I think it actually extended through Oklahoma and extended, way past Oklahoma. But anyway, they're trying to say that something written by men and women magically applies to everybody in this enormous geographic area. Some people, have never seen it, never heard of it, but it applies to them apparently. We don't believe that just saying things on a piece of paper makes it true. Be a skeptic, just being an adult. Just actually challenging these things and not accepting that, well, it's true because we said so. Or it's true because some dead white guy said so. Some dead white slave owner said so. No, we don't accept that. Something is not true just because you say it's true. There has to be some proof. There has to be some logic and rationale behind supporting the claim. And that's why we start doing it, and like we filed a motion to dismiss, and we are challenging the foundation of the prosecution's claim. The entire foundation of the claim is that this written instrument, at least when you're in Texas, written instrument from 1836, applies to everyone because we said so. We don't believe that that's true. We don't even believe that there's evidence to show that there is a state and that there is a government that's actually prosecuting you. Because forcing people to give you money doesn't create obligations of protection and allegiance. That's why critics will turn around and say, well, you're using too narrow a definition of citizen. You can't just use that definition. You can't use that definition, even though it's in a Supreme Court decision. You can't use that in a different context. Well, bottom line, this is something I went through with the IRS yesterday, and I should have, hopefully I have time for that. This I might actually get as a call of shame. Let me get my notes out because I almost forgot about that. Because what it comes down to is whether someone is a citizen or not, or a resident, whether you talk about allegiance and protection is almost irrelevant, because bottom line, the Constitution, which is just a written instrument, has to apply to them. The presumption is that, like with me, I was born in Cheektowaga. There you go again with the indigenous names. I was born in a hospital in Cheektowaga. And the presumption is that because I was born physically in Cheektowaga, which is in a certain part of North America, that this written instrument, nobody bothered to sign, applies to me. There's no actual evidence other than they say so. Now, that doesn't prove it. So their entire foundation rests on that. That they're saying it applies. So, like I've mentioned before about the citizens, and that there has to be a body politic which is made up of citizens owing a duty of allegiance in return for a duty of protection, which I've mentioned a lot of times. Forcing people to pay you doesn't create these obligations. Saying a written instrument applies to you and now makes you a citizen doesn't do that. Just saying things doesn't. Vox et praeterea nihil. Yeah, I know my Latin is absolutely awful, but it's just the voice. It's voice, not the more. Okay, just look. You don't want to accept the double standard anyway, right? Is something true just because I say it? No. Well, you know what? That applies to everybody, even if they call themselves a government. And the only other way to try to say that that's true and to argue that that's true is to be raising a double standard. It's the same thing as if it's wrong morally and criminal in the lay sense for me to go out and force perfect strangers to give me money. Well, you know what? It's immoral for everyone to do it, and it's criminal for everybody. So this is the reason why we can confidently go in and say that the prosecution has no evidence. Because you could say, well, just because you have only the police ticket, the cop's ticket at this time, there's certainly his police report, and there could be evidence in there. Well, there's not. The only factual issues in a typical thing, like we're talking here, like with Chris in Texas, Cherokee County, Texas, is his physical location. Your physical location doesn't mean that a written instrument applies to you. It's that simple. We're not interested in your magical explanations or your philosophy at the peril of a gun. We're not interested in that. So, because the prosecutor, under no circumstances, can produce any actual proof that these written instruments apply to us, they can't show a valid cause of action, which would give the court jurisdiction. It's called subject matter jurisdiction because courts are limited to only what? Justiciable cases of controversies. And that is a legitimate case or controversy, meaning there has to be a violation of a legal right or a legal injury that causes loss, harm, or damage. You've got to have that and redressability to have standing to then give the court subject matter jurisdiction. Just because they have jurisdiction in traffic cases, the operative word, as I've said so many times, the operative word there is case. A case is the violation of legal right and damage in a general sense. There's different ways that you could be injured, there's different ways you could be damaged, but that is in a general sense. That's why they talk about injuria et damnum, injury and damage, the legal injury and damage. And that all stems, the legal injury is going to be the violation of their sacred writ, which of course there's no damn evidence. So that's why we can go in and ask these questions. So one of the things we ask on a Brady request, okay, one of the things we ask for in the Brady request, of course, is, and this is something, of course, Chris did. This is what we have as a standard part of the motion to dismiss and the Brady request that we have at markstevens.net. You're asking for the witness with personal knowledge to support the claim that the laws apply to you and you violated them. Now, the police officer is going to typically be the only witness. So, does he have personal first-hand knowledge? Remember, don't let anybody kid you. Just because someone is a Juris Doctorate, just because they have a lot more experience in the courts than you, doesn't mean that what they're saying to you is true. Don't let anyone try to fool you. You question them on this. If somebody tells you, look, you cannot ask questions of the police officer about the law, question them on it. Use the Socratic method. Just let me see if I understand you correctly. You're telling me that even though the police officer has testified that the laws apply to me, I can't ask him questions about the law on cross-examination. And depending on what kind of stupid answer you get from them, follow it up. Make them wish they never made such a claim to you. You're telling me, and you've been to law school, and you're an experienced attorney, you're telling me that prior statements made by the police officer, prior statements under oath, okay, are not subject to challenge on cross-examination. That's your position. Because I'm telling you right now, competency and credibility are absolutely proper and relevant on any cross-examination. And the only reason why someone is telling you that is because the claim that their laws apply to you is so easily discredited, they have to erect this scaffolding of legalistic BS to try to trick you and to try to get you intimidated to think that you are not making a legitimate challenge, that you are not making an effective defense. And that's why when you go to markstevens.net and you see documents like this, which I'll get posted, and yes, it is Texas. Thanks, Chris. They have to make excuses. They'll turn around and say that the prosecutor, in this case, didn't withdraw because they couldn't overcome the motion or that they didn't have evidence to make their case. They had plenty of evidence to make their case. They withdrew because you were too much trouble. Well, now, look, that's what we call cherry picking. It is too much trouble to prosecute someone like Chris here. Why? Because we're hitting them square over the head with a Brady request and a motion where we're showing that they do not have the evidence. That the only way to overcome the motion to dismiss is to provide the evidence, but they never do. Judge Crissetti recently, I don't remember mentioning this, but Judge Crissetti up in Vermont, he turned around and stated that in writing that the prosecution didn't have to present such evidence before the trial. That it's a trial issue only. That there is where they have to present the evidence to prove beyond a reasonable doubt. This is a lie, of course. Of course this is a lie. Because the prosecution, this is just, look, it's amazing that judges get away with this. They get away with this because it's a criminal organization and not enough of us are challenging these people. We have to take Judge Cressetti to task. Yes, I'm talking to Brian and others. We have to go to the city council, the county commissioners, and bring these things out. And when they say something, well, we've got nothing to do with the courts, but you've got something to do with your prosecutors. And if you know that the judge is doing something wrong, your prosecutors have an obligation, an ethical obligation. I know, stop laughing. Lawyers have an ethical obligation that when they know it's not supported by probable cause, when they know there's not evidence, they have to withdraw, just like this lawyer did in Texas against Chris. They withdrew. And that's what I believe happened. The prosecutor knew that they couldn't make their case, knew that Chris could annihilate their position in front of a jury. And to avoid that, it was easier to just let it go, which they did with prejudice, which means they can't refile it. Now, the reason why it's with prejudice is probably because something really bad happened. Otherwise, they would just do it without prejudice so the prosecutor can bring it back. But it's not. It's with prejudice. If they had how many times have we said this on the show? If they had the proof, they would just present it. But they don't. So that's why we get these things thrown out. There's no way in the world that a police officer could have personal knowledge. Now I can't even edit that out. I'm on a live stream and I can't edit that damn thing out. But maybe one of these days I'll take one of these, one of these robocalls. There's no way that the police officer could possibly have personal knowledge that the laws apply to you. And the prosecutor has to know that. He has to do an investigation with his witness and find out if they have personal knowledge of the matters they're testifying to. Now, you could turn around and say, yeah, but Mark, he's not looking at it the same way that you are. He's not looking at it from a standpoint that he's got to show that the laws apply. And that might be true. He's doing it out of innocence first, but definitely not after he gets that Brady request. After he gets the Brady request, he now knows that you are asking for evidence to support his claim that the laws apply to you, and you have to have not only the evidence, you've got to have a witness with personal first-hand knowledge. Rule 602, they don't like it when it comes to their opinions. Oh, they don't like when you, no, that's why I've mentioned no insults. Dick Noble up in the Big D, up in Michigan, Detroit, throwing a man in jail just for asking a question. They don't like to be challenged. And that's something that needs to go in front of the city councils and the county commissioners. Let them know that what these judges and prosecutors are doing. Because at the very least, what you're doing is not only getting stuff that we can post up on YouTube and expose these people for the criminals that they are, which is what we're doing in court. But now, you've got a stronger case if you file against the insurance. So you can actually link in or put a link into your complaint against their insurance. Hey, I brought it to the city council, and these guys did nothing. Nothing. We tried to stop them. And yeah, cities, at least the smaller ones, it's been shown, in fact, there's contemporary cases about this, have lost their insurance. So one of the things that's got to go is the police department. You could just do a quick Google search and you can find some of those where that's happened. Yes, I know they're smaller, but we want to work to make it with larger ones. Could you imagine a municipality as large as Phoenix, or even something like Tucson, or a smaller place, if they lost their insurance? Yeah, that would be bad. They have to have insurance. I guess they could just do like what the feds do and say screw it and not have that. Or like in California. Yes, in California they don't self-insure and they don't bond, so you're kind of SOL there. You got to bring a claim to the legislature, and then they have to pass a bill to if they accept it. But this is important that the insurance, so in your claim against the insurance company, you can show, I did everything I could to stop them. These people are on the hook. Because now, the bosses, remember, first rule of management, everything is the manager's fault. So now you've got the city council who's aware of these damages that are being caused, and they're doing nothing about it. So they could have stopped it, but they didn't. So it should make for an easier prosecution if you have to take it to court. I mean civil prosecution. Yeah, well, you don't want to get caught up in legalese, but when you bring a civil action to recover damages, because the insurance company turns you down. But it's going to look much better for you and a lot worse for them when you say, I went to the city council on XYZ days, and I showed them, I gave them the evidence. They did nothing. They had every opportunity to stop this, so they can't claim negligence. We didn't know the judge was doing that. We didn't realize the prosecutor was out of control. We didn't know. Yes, you did. Of course you know. They know. They just don't always do it. So I want to congratulate Chris. They're operating there in Texas. In Cherokee. Where the hell's the docket? There you go. Dismissed with prejudice. This is the effectiveness, I believe, of the Socratic method. And for those who are new, and I think it's great where, you know, the show is already doing, I don't even want to say how many times better doing our live stream. Still probably going to do much better when we get it posted on YouTube and on my website. But I'm very glad to see the number of people that have tuned in to the live show. And always, I know we get the live stream, the stream also goes to the Skype chat, which is that we got a lot more people there. So I appreciate that. And if you are looking to defend or just to learn how to defend against these predators, then use the link at markstevens.net under upcoming events. The Skype link will bring you directly to the main chat, and then you can let everybody know, hey, I want to learn how to do this, and they'll set up another room, and then you could do a voice call. And you don't have to participate the first time or so. I encourage it, but you don't have to. You can just listen to that. We need to do that. We need to be challenging these people because they're criminals. And one thing that they don't want is to be exposed. And we need more people to do this. I'll have to get Tony's linked on my website at markstevens.net so people can see that. But this is just one of many. I do congratulate Chris for standing up to these predators and getting this dismissal. It's because they didn't have a shred of evidence, not a single shred of evidence. If they had it, they would present it, and that's something that you gotta realize that you have to hone. This is what the role playing helps to do. You have to hone your BS skills. You have to be able to recognize it right away, and one of the beauties when we go to court is I always recommend. Now this is in and out of court because this happened a couple days ago with the Internal Revenue Service. It was Tuesday with the Internal Revenue Service. And this is a situation where they wanted someone to come in for an audit. He asked for evidence of jurisdiction and wound up not participating. As much as they make my skin crawl, I would always see a face-to-face confrontation with them as an opportunity to get some evidence on them, some admissions from them that we can use against them later. So even if you got to do it over the phone, or what you could do is you could be there in person and then I can be on the phone and I can deal with the agent. But if you're not there in person, it's more difficult for me to do it over the phone. You and I would have to do it. So what happened here was he didn't show up. They went based on the information that they had coerced out of other companies, and they came up with a number, let's just say $12 million. And just insisting that this was owed. And so I walked the agent through, and they're saying that the only remedy now is tax court, but you can appeal it administratively in some cases, and the tax court is not a remedy. If you get one thing from this show today, it is never filed into tax court. You will get screwed, okay? I am actually giving legal advice at this point. I am advising everyone within the sound of my voice, never, ever, 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 ever go into the tax court, because you cannot even, Look, we've never gotten them stripped of a presumption of correctness, even when we had their own admission that it wasn't based on evidence. And Adamson versus Commissioner is just one of them. Helving versus Taylor, U.S. Supreme Court. If the assessment is not based on evidence, they have to be. It's got to be thrown out. But at a bare minimum, it strips the IRS of their presumption of correctness, which only arises when there's evidence. But they won't do it. They won't do it. That Michael B. Thornton is just one of them. They won't do it. Even when Michael Rakin admitted 3 times he had no evidence, Michael stood firm. Denied, denied, denied. Well, actually, I think some clerk just rubber stamped it for him because he was probably busy playing golf or something. So, tax court, not an option. Never an option. So, what I did was I walked this woman through asking questions. And this is the thing. You're using just their statements against them. That's the beauty of the Socratic method. And you always know when you get a responsive answer or not because you're asking leading questions. Leading questions are yes or no questions, right? Yes or no questions. So if they give you something other than yes or no, that's a cue. Oh, they're not answering the question. Ask it again. So when you listen to the Call of Shame, and I should get that up there this week, yes, there's a lot of repetition, but that's for a reason, and it's getting to a certain point. And so what she was getting at here was she was saying that the laws do apply, and she made the determination that the laws apply. And I brought her through asking certain questions to get to a point where she would refuse to answer the question. And first, she didn't like to answer the question. I said, well, all right, let me look. All right, so what she did was she stated that when I asked about how she determined the Constitution applied, she made this thing that I was challenging the Constitution, and she was not going to get into a legal debate with me. Again, all it is a dodge to not answering the question. And that's why the first thing I'm thinking of is Inigo Montoya. You keep using that word debate. I don't think it means what you think it does. A cross-examination is not a debate. Okay? And that's why I wrote in Government Indicted, treat your interaction with them as if it is a cross-examination. All leading questions, which means the information is in the question. A non-leading question is the information has to be supplied by the person that you are interviewing. So she turned around, and to get around that, because it was so uncomfortable with her about that, she kept on saying, but I made my decision based on the law. Isn't your law based on the Constitution? I mean, doesn't your own form, don't your own form letters say that the basis of your jurisdiction and your laws is the Constitution? She don't want to answer that. So I figured, well, let's just go based on the law. So the one question that really, really sealed it for this particular call was, when you determined that the laws applied to Mr. X, did you assume that they applied, or did you base it off of evidence? She tried to accuse me of arguing the validity of the law. I know. You gotta keep from laughing. But hey, forcing people to pay you means never having to answer a question or show any professional whatsoever. So my asking her if she assumed the laws applied or she based it off of evidence is somehow arguing the validity of the law. And that is something, if you're new to this material, that is actually a very, very common complaint that critics have. We have about 4 or 5 critics over the years, and they'll say, well, you're challenging the law. No, we're challenging an agent's application of that law. We're just challenging their claim. Well, that's the same thing as challenging the law. No. I'm going to have to go ahead and disagree with you there. If I turn around and say that Congress is a bunch of they're guilty of multiple homicides, and they ask me for the evidence to prove that that's true, that's not a challenge to the homicide law. Remember turnabout. Always turn it back on them in the form of a question. See if that's really their position. So I asked her again after having her begrudgingly agree I was not arguing or challenging the validity of the law. Because I asked her, do you think you're acting in good faith right now by not answering my question directly? So she finally says, I am refusing to answer your question and I'm going to end the phone call. I want to repeat the question because it's one that I say many times. When you get them to that point, it ultimately doesn't matter if they answer the question or not. The question on its own, without being answered, is going to raise an eyebrow and cast quite a cloud over their credibility. It's like if I ask, look, if I was to do things like the government and I was to force strangers to give me money, would you consider me a criminal? Not answering that question, people know it's because, oh, yeah, you got him. You got him. You got him. It's the same here. So if I ask somebody or you ask somebody, did you assume X or was X based on evidence? And they say, I'm not going to answer that question. Boom, you got them. You're not answering the question. So now excuses were made, and she put me off to the supervisor who was saying that it's not appropriate for her to answer questions at this time. That my remedy is in the tax court, and then I could always do a deposition. Yeah, apparently this guy's not familiar with the tax court. I think he was just flat out lying there. So, so they refused. He said it was by law that she could that it was inappropriate to ask those questions. I said, inappropriate by law? Really? Can you cite it? He couldn't. Couldn't do it. This is why I really got to get this call posted, because I forgot here in my notes. One of the most common tactics that they'll use to avoid answering your question is to say, well, now you're twisting my words. This is why it takes sometimes so long. This is why interviews with people like Kelly and Conway take so much longer than they usually have to take, because instead of just answering the question, you got to, they just evade and come out with this BS. Just answer the damn question. That's why we have to keep track of their answers, and we just use their answers against them. I followed the law. Did you assume it applied here, or was it based on evidence? I'm not going to answer that. Good Lord. Okay, I got a little more from Chris. He posted this. First arraignment lasted about 3 minutes of me asking about jurisdiction before the judge entered a plea of not guilty on the prosecutor's behalf, not my... Okay, wow. Interesting. Very interesting there, Chris. I immediately filed a motion in limine and another motion to dismiss based on judicial misconduct and prosecutorial misconduct. I didn't hear back for almost a year. Then I got a letter saying pretrial conference had been set. At the conference, I again challenged jurisdiction and again requested my Brady information be given, and I wouldn't take any of their deals, so they set a court date. Then about a week later, I got the dismissal in the mail. So there's a little more information that we have regarding that. And that's what we need to do, just like with this IRS agent. I backed her into a corner with her own statements. And how could you get any slimier than, I'm not going to answer your questions anymore? Think about that. Did you... Look... This goes right to some of the criticism and some of the gaslighting that we're going to hear in these courts. Are you seriously challenging whether the laws apply to you or not? Look at the responses you get. If it was so obvious and so easy to show that these rules, these laws apply to us, why can't they ever just prove it? They can't even answer a simple question because they know they've already gone through 15 minutes of the Socratic method with me, and I've been nailing them on their own statements. So they know if they say yes or no, they're in deep trouble. Yes or no, did you assume the laws applied, or was it based on evidence? Well, they know there's no evidence, and they know if they say they assumed it, that that's bad faith. If they assumed it, they have no jurisdiction. If they assumed it, they don't have a presumption of correctness. So the burden of proof never shifts. And if the burden of proof never shifts, they got nothing. They got nothing. But they still put these things through the mail as if they were true. My gosh, it is. I want to impress on everybody that to know that not only can I do this, a schmuck from Long Island, Chris in Texas was able to. What he did and what he goes through there, what he related, was he was unrelenting on his challenge to the prosecution's evidence. I'm not taking a deal. I want to see the evidence. So for those who don't know, wow, we're almost done with the show here today. For those who don't know what a motion in limine is, yeah, I know it sounds kind of, I don't even know exactly what that Latin phrase means, but I know what a motion in limine is. A motion in limine is used to limit argument and evidence at trial. And we use it based on the prosecution's lack of evidence and lack of Brady material to even be able to argue that the laws apply. No one should get to argue the laws apply if they're just assuming it. No one should get to argue anything unless it's based on evidence and logic. This idea that you can ruin people's lives, you can make claims that they owe thousands of dollars on an assumption, and then turn around and, you go to tax court. Show me one person who has ever challenged underlying liability, get a deposition on an IRS agent. Let alone, that not only could you never get to a point where you can get discovery, because every time we've done it, it has been denied. Every single time it has been denied. But show me one person who challenged underlying liability, one, that was able to strip the IRS of their presumption of correctness. Just show me one citation. One. It doesn't matter if they won or lost, ultimately. I don't care. Show me one example where the IRS was stripped of their presumption of correctness. I would love to see it. Show where the tax court did that. I'm not talking about commissioner versus, like Gitlitz versus commissioner. They lost ultimately at the Supreme Court and it was sent back. I want someone to show me one reported instance where the IRS lost their presumption of correctness. I've never heard of it. So it's disingenuous at best. Well, you have to get going to the tax court. No, that's a nice way of saying to go F yourself. How about fongo? That's what they're saying to you there. But it's that simple. Hell, you could even start off with that. I don't recommend it, but you could say, hey, when you made the determination that the laws applied to me, was that an assumption or was it based on evidence? Watch how quickly they fold. So someone's asking here, can anyone that has some idea, is live streaming new for the No Stay Project? It's only new on YouTube. We've been doing this is episode 32 of the Wednesday edition of the No Stay Project. So, and we have live audio only, of course, we've done for years on LRN.FM. That's the Saturday one. And since we're almost out of time, I do have to mention we are not live this Saturday. I'm sorry. Hey, maybe I'll do a Friday broadcast here on YouTube since it seems to be working pretty good. And then maybe I'll have my caller line working. But we'll see. Something that's happened on live broadcasts before. So what happened was I need to give a call to the other supervisor and find out what's going on. If they have a law saying it's inappropriate to discuss these matters, I want to see it. Cite it. And that's one thing we should do in court too. I am going to rule as a matter of law. Cite it. Well, you can make it up too. Well, that's not what the law says. I know that there's a law that says the complete opposite of that. Well, cite it. Well, apparently we don't have to cite anything in this court. We could just go back and forth like this. So one of the things that I had said, again, we want to assume that everything they're saying is a lie because chances are it is. But what it does is it sharpens our focus. We are going to get in the habit of always challenging everything. So what I said, look, if we assume that it's correct that what you said, that it's inappropriate by law for Ms. Jones to answer my questions. She has been answering my questions for the better part of, let's say 10 minutes. So is she in some kind of trouble now? I said, I have a witness to this. He wouldn't answer. So if it was prohibited by law for her to answer questions, and I have her on record answering a whole bunch of questions, wouldn't that be a violation of the sacred law? Couldn't she be in trouble? Yeah, no wonder they want to end that phone call. No damn wonder. It's no surprise. But hey, they're criminals. And he said, well, Mark, where's your proof? How many times? I'll keep saying it. The proof is they force people to pay them. That's the only evidence that we need to show that they are criminals. Now, somebody did mention something here. Somebody mentioned something here about admiralty law. Now, I am not one of these Freeman patriot types. I'm a voluntarist, an anarchist. I don't believe in ruling classes. I believe in rules, and a rule of do no harm and treat others the way you want to be treated. I believe that should be applied to everyone. So I don't buy into this, well, the traffic courts are admiralty law. There's not a shred of evidence to prove that. The fringe on a flag does not prove that. And bottom line here, is it relevant what they're calling the jurisdiction? The whole thing rests on a foundation of you're here in Arizona, this written instrument applies, meaning the Constitution. If you're in this area, this written instrument applies. It doesn't matter if they're calling it admiralty, maritime, a court-martial, common law, what's the other one? Statutory. None of that matters because there's no evidence for them to show that their written instrument applies to you just because you're in the area. There's not a single piece of evidence to show that. There's no meaningful connection whatsoever between a written instrument and your physical location. But they can put you in prison. Yeah. Well, who the hell is doubting that? The fact that they can put you in prison is just more evidence of their criminal nature. But they can prove that you violate. You didn't have a driver's license. You're supposed to have one. Where's the evidence the law applies in the first place? But you were on the road. Does my physical location prove a written instrument applies to me? Again, are you assuming the law applies to me, or is it based on evidence? It's the same thing as when this judge snaps at you that they have I assure you this court has jurisdiction. Objection, is that because you said so, or because the prosecution's evidence does? So what you're doing is, and it's not a false dichotomy. Either they have evidence and proof, or they don't. Either they assumed it, or they didn't. They went based on the evidence. One is objective. This is what the data says. Well, this is the strongest argument that the data, from the data, as opposed to an assumption. Well, I think so. Just like what Wesley Serra does. Judge throws out the complaint in Wisconsin. Throws it out. Grants the motion to dismiss. And says, it's just because the judge was pissed off. Is it possible that that happened to Wes when he was a prosecutor? That he was told to F off? Sure. I think Wes deserves a big fungal. But that's not proof that that's what happened in Wisconsin. Deductive reasoning. Much, much stronger. Much better form of reasoning than inductive. Especially when you've got a narrative to push. Go based on the evidence before you. Occam's razor. The simplest explanation, without any assumptions or the fewest assumptions, is usually the right one. So here, don't go with the assumptions. Go with what the evidence is before you. Hey, I can't believe we're already out of time for this first broadcast here on YouTube. Again, I should have mentioned, thanks to Matthew. Matt in Brisbane, thanks, mate. Appreciate that. All possible because of him and, of course, Calvin for putting it together. This has been episode 32 of That There No Stay Project. here on, well, no, it's on YouTube, the first one. So maybe we'll, 32, it's episode 32. It's August 30th, 2017. Glad to have been able to join everybody here live at the No State Project here in the Fortified Compound. We won't be live on Saturday, unfortunately. I'm really sorry about that. But next Wednesday, hopefully in HD, and with a caller line here, we'll do that. So if you disagree with anything that I said on the show, please feel free to call into a live broadcast or send it on the chat or post it on the forum. Call me during another live broadcast on Saturday and show where my analysis is wrong, where the facts are wrong and my logic is fallacious. So I appreciate everyone tuning in. My name is Mark Stevens. The website is markstevens.net. Until next time, salud.